any.
Morning.
How's it going?
Good to you.
Pretty good.
Testing, 1, 2, 3, mic check.
Hey, how's it going?
I'm Sam.
Steve Forsberg.
Nice to meet you in the flesh.
Just so you know, we have unmuted the courtroom, so anything you can say, you're up to. Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. This is S-1-SC-39058, State of New Mexico versus Chavez. Can I have entries of appearance, please?
Van Snow for the state. Steve Forsberg on behalf of Matthew Chavez.
Thank you, gentlemen. Mr. Snow, it looks like you have reserved 20 minutes for your argument in chief and 10 for rebuttal.
Yes, sir.
All right, you may proceed.
May it please the court, counsel. This court should reverse the Court of Appeals and hold that defendant was not entitled to a manslaughter instruction under an imperfect self-defense theory because he was the initial aggressor. Ruling that initial aggressors, especially those who commit inherently dangerous felonies, cannot claim imperfect self-defense would be a modest and logical development of existing precedent and would clarify this area of law. Defendant started the fight by trying to rob Tyler Lackey. He was not entitled to a manslaughter instruction under either of the state's proposed rules. His claim would also fail under existing law. Attempting to rob someone should count as an intentional assault. Defendant, under existing law then, could not count on Lackey's reasonable response so as to constitute sufficient provocation. We know that the jury rejected the view that Lackey became the aggressor or acted unreasonably. Accordingly, defendant's claim would fail under.
That's because they were given a pure self-defense instruction, correct? Not a lesser self-defense instruction.
Correct, Your Honor.
So what can we read from that if we had because one jury's instruction lead potentially to a different conclusion. So I'm not sure we can say that the jury disagreed wholeheartedly.
Your Honor, in this particular case with these facts and defendant's theory, it was defendant's theory that he argued to the jury that although he may have been the initial aggressor, he regained his right to kill in self-defense because Lackey pursued him, wouldn't let him leave, threatened deadly force. He believed he was going to get shot. If the jury agreed with this account of events, it would have acquitted on a perfect self-defense theory because Lackey would have used unreasonable force.
But they could have just said it wasn't reasonable. That's the difference between the self-defense and the provocation. And the jury instructions, 14.213 lay that out. It's interesting that in instruction 15, they handwrite in self-defense, but not provocation. Or those aren't the same thing, are they?
No, Your Honor, sufficient provocation and
Self-defense is a pure defense.
yes, sir.
It's absolute. It's acquittal, like you said. But provocation is not that. Provocation just says, I didn't do it to a level of second-degree murder.
Your Honor, under existing law, sufficient provocation isn't just a subjective requirement. There's also the objectively reasonable requirement. Voluntary manslaughter exists because society recognizes that some homicides, intentional homicides, are less culpable because a defendant is temporarily overcome by some sort of extreme emotion. As such that
Why don't the facts here match that? Because there is a reading of the evidence that calls into question whether the defendant here had a gun or not. So if he goes up and uses his fists, and then the response is gun, why isn't that enough to elevate it to the idea of fear of life? And I'm going to act accordingly.
Yes, Your Honor. So here, the jury would have acquitted under that theory, but the jury did not find that Lackey used unreasonable force. As part of that,
the jury was not asked to find whether the defendant tried to leave the encounter. They were not asked to make that decision.
I believe that the jury was instructed that as part of the self-defense instruction, that an initial aggressor is not entitled to claim perfect self-defense, but that Lackey could have become the aggressor if he had pursued or used unreasonable force. I believe
That's
that the jury.
different. That's a different question
Then
than him trying to leave. Under the facts of this case as testified to by the defendant's partner in the crime, he was trying to leave. Leave us alone. Forget it. Just let us go. They were not asked to make that determination as to whether that actually occurred.
Your Honor, I believe that as the jury, as instructed, was instructed on the withdrawal, that if they believed defendant's story that he withdrew and that Lackey became the aggressor, they would have acquitted on perfect self-defense, and there would have been no need.
They wouldn't have, though, because they would have had to found it was a lawful act. I guess the core question is, are we recognizing a distinction between the provocation that's included in a lot of these instructions, including the step-down instruction of 14.213, or pure self-defense? It's because you're arguing, it seems to me, and the concurrence is arguing, it seems to me, as a matter of law, you do not get this instruction. You do not get a provocation. It's self-defense or nothing. I could be wrong, but that's how I'm seeing this. I'm not saying the jury could have found this. You're probably right. Or they could have found this. But they weren't given the option. And it's being argued here, they don't get that option. Am I overreading the concurrence in your position?
Your Honor is correct that it's the state's position that as a matter of law, defendant shouldn't have gotten instruction. But it's also the state's position that if this court concludes that the jury should have been instructed, we know because of the unique factual circumstance, defendant's theory, and our procedural position, that that isn't the view that the jury found.
So let me go, or go ahead.
So then are you saying it's harmless error?
If this court concludes that an instruction should have been given, it's the state's position that it was harmless. And that if there's an initial aggressor component that is on voluntary manslaughter, the jury would have reached the same conclusion, even if instructed on manslaughter.
So you're not just asking us to make a declaration for purposes of this case. You're asking us to make a declaration for all cases.
Yes, sir.
When you're requesting relief. So I want to try and test that a little bit. It seems to me that if I instigate an encounter with somebody, saying I'm using brass knuckles, and I am, beating somebody up, like how I beat somebody up, I would do that. But I'm the initial aggressor, and the response is a gun, that this idea of reasonableness is dead in this area of case law, because I punch somebody, we are no longer going to look at the reasonableness of the response to the punch. So you're asking for strict liability.
You're
If you're the initial aggressor, regardless of what level of aggression it is.
To clarify the state's position, even if this court adopts the broadest version of the state's rule and rules that one who starts an encounter with an inherently dangerous felony can't argue imperfect self-defense, that would still leave the possibility to argue for perfect self-defense. So even if an aggressor starts off with an inherently dangerous felony, if the victim acts clearly unreasonably, a defendant could retain his right to kill so long as it's justifiable. The state's proposed rule would just prevent the defendant from starting an encounter and then making an unreasonable decision to kill, and then being able to argue that his conduct was less culpable. So the state's rule, even at its most maximal extent, wouldn't completely bar situations such as Your Honor proposed.
You said an unreasonable decision to kill.
Yes, sir.
That's a decision for the jury to make.
And here we know that the jury didn't believe.
Well, they may not have believed he was the initial aggressor, but they were not instructed, as I understand it, to determine whether or not the defendant tried to terminate the encounter. Where in the instruction was the jury asked to determine whether the defendant terminated the encounter, sought to terminate the encounter?
Your Honor, I don't have the record cited with me at the moment, but I believe the jury was instructed that an initial aggressor cannot claim self-defense, but that if an initial aggressor withdraws, he can regain his right to kill. The jury was able to make that determination. That was defendant's entire theory of the case, was that he had withdrawn. The encounter ended at the ATM. And then his claim was that Lackey pursued him, starting another encounter, and therefore he regained his perfect right to kill in self-defense. If the jury had believed that, they would have acquitted him. But as instructed, it appears the jury believed.
That's just contrary to all notions regarding manslaughter. So you're asking us to turn our backs on the concept that if there's an honest but unreasonable belief that you have to use force to defend yourself, that manslaughter is not available anymore.
So, Your Honor, this brings up an interesting area of uncertainty in New Mexico law. It's not clear precisely what circumstances in which imperfect self-defense is available. Some states clearly limit it's only available, for example, when a defendant uses unreasonable force. And that is, I believe this was dicta, but it's in Henley, the conception that this court gave of imperfect self-defense was one who is lawfully engaging in self-defense, but uses an unreasonable amount of force. Mm-hmm. So one could still argue imperfect self-defense and it would still serve a function.
How can we argue imperfect self-defense if you're taking the position that we should have strict scrutiny on first aggressor?
Your Honor,
I think those are inherently in conflict.
In many, I meant to say in many cases. In a typical manslaughter case where there's a mutual exchange of blows, there's kind of a fracas, it's not clear, somebody makes a movement for a gun, the other person gets shot. So that would be, for example, Jernigan, I believe is how pronounces it. It was that sort of scuffle where there was kind of an initial shoving, punching. The victim makes a movement going for the belt, and defendant testified, I believe that, you know, he was going for a gun and shot him. It would still be available in cases like that, but not in cases where the aggressor makes the conscious intentional decision to commit an inherently dangerous felony.
So you talked, I'm sorry, complete that answer and then I'll ask.
So in sum, it's the state's position that imperfect self-defense serves a purpose, it should exist, but not in cases where there's the initial aggressor who commits an inherently dangerous felony.
Okay, so inherently dangerous felony. It sounds to me, that language to me sounds like felony murder. And
Yep.
that's what's in the concurrence. He seems to say, and tell me if I'm misreading it, the danger of our current state of the law is in a felony murder case, the first aggressor can have this imperfect defense. The problem with this case is they acquitted on felony murder. They looked at whether the murder was committed in the commission of the felony. That's the other thing we know about this jury. And with regard to facts of this case, it's a hard rule to draw. I mean, I think the concurrence is asking too much of us in this case because they acquitted on that. Is there any impact on that acquittal of the felony murder?
Yes, Your Honor. So that's an important point to highlight. I also looked at that and kind of thought that was a curious ruling. It appears what the jury believed was that the robbery ended when Lackey foiled it, but that the encounter continued. Because if they had viewed the robbery and the encounter as coterminous, then defendant would have had a perfect self-defense, because then there would have been no provocation. The encounter would have stopped at the ATM, just like defendant's theory of the case was. So it appears from the jury's verdicts, they believe the attempted robbery ended, but the encounter was still going.
So as a rule, you would not allow this defense. Where do we define inherently dangerous? Or do we say in commission of any felony murder that we've announced, because the statute just says any felony? What is inherently dangerous?
Yes,
Is
Your
the
Honor.
jury instructed on that?
The jury was not instructed on that, Your Honor. The state, for the purposes of this argument, believes as a working definition, inherently dangerous means it, under the facts of the case, involved the actual or threatened use of force. And the terminology that inherently dangerous, the state drew that from, granted, it's a different area of law, but this court's opinions about when police can pat down suspects, this per se rule. And also to touch on the area of felony murder, because defendant brought that up in his briefing. To clarify, felony murder was so problematic at common law because it could punish an unintentional homicide that the defendant wasn't even causally connected to as the most culpable form of homicide, whereas others who intentionally killed were receiving a less punishment. So this rule would instead punish culpable intentional homicides as culpable intentional homicides. It just wouldn't let defendants claim lessened mitigation that society has to recognize as objectively reasonable.
So are we in the position, I mean, why, you have this definition you came up with for inherently dangerous felonies, and you're asking us to basically completely deprive someone of a mitigating circumstance. Why should we be doing that as opposed to the legislature? Because it seems like you're asking us to create a definition and create circumstances and create a bright line rule that has just not existed in New Mexico previously, not to this extent.
Yes, Your Honor, and the defendant also kind of brought up in his briefing, alluding to the fact that this court might not have the ability. So as sufficient provocation exists already, there's an objective component. The provocation must be such that would cause I don't have the language of the jury instruction in front of me, but a reasonable person to be overcome by the fear. So it's one who intentionally seeks out and provokes and commits a crime that necessarily involves the actual or threatened use of force can be reasonably expected to anticipate that's going to provoke a violent response. So it would just be an expansion of that existing objective hook that's already in the law as it stands. And just clarifying and expanding on that society is not prepared to recognize this as objectively reasonable. So it would be an expansion of what this court has already done in expanding on the legislative crime of voluntary manslaughter.
So you've created a category of justifiable homicide. So if you have an initial aggressor engaged in an inherently dangerous felony, as you've described it, the victim of that inherently dangerous felony has a right to shoot and kill that aggressor.
Your Honor, only if the initial aggressor lost his status.
Pardon me?
Only if the initial aggressor lost his aggressor status.
Well,
So if he's no longer the aggressor, then the victim gets to shoot?
Oh, I'm sorry, I believe I misunderstood Your Honor's question. Could you please repeat?
well, I think what you're saying is in this day, people have concealed carry guns and everything else, and that gives, under your theory, the victim of the inherently and dangerous felony has a right to shoot and kill the initial aggressor.
To be clear, if the victim acted unreasonably under the circumstances, that would not be a justifiable homicide.
But that's the flip side of what you're arguing. And the reasonableness is always the jury's prerogative to determine under either scenario.
So if I'm understanding,
Whether the victim shoots and kills the aggressor or the defendant shoots and kills the victim.
yes, Your Honor.
Reasonableness is the touchstone of how you determine what the crime is.
Yes, oftentimes, but as this court in Gaitan held, it was not error in that case to refuse an instruction on imperfect self-defense at all. There are some instances in which it is proper.
As a matter of law.
Yes, Your Honor, as this court held in Gaitan. And to clarify, if a victim does shoot in response to an actual attack and it's unreasonable, that person would be subject to criminal prosecution. So it wouldn't be a new type of justified homicide, to clarify that.
So they can shoot at each other. You have a shootout. And depending on who's the initial aggressor, determines who's liable
Yes, Your Honor.
or
And
who's dead.
that is where we stand with existing law. But the state's rule by disincentivizing not only the eventual resort to the homicide, but also engaging in an inherently dangerous crime in the first place would work against that. So I'm running very low on time.
Can I just ask you
Yes,
about
Your
the
Honor.
instruction 15, where they hand wrote in self-defense? Why did they depart from 14-213 that has provocation in it?
I'm not sure. I think that was left out as an element, just as an element of second-degree murder. They had to find beyond a reasonable doubt. Even I'm not certain.
Okay, that's fair.
And I actually believe it was likely due to the fact that the court had denied the manslaughter instruction.
Okay.
So with my short remaining time, if the court doesn't have other questions, I'd like to just touch on the IAD argument. So defendant's IAD claims for three independent reasons. First, he waived the deadline by agreeing to a trial date that he now complains of. And under New York versus Hill, a unanimous Supreme Court held that similar conduct waives. Even if he hadn't waived it, he failed to invoke the IAD. The record is bereft of no hard information. To clear up a quick point, defendant claimed in his reply that the supplemental record contains a signature from the judge. It does not. The supplemental record contains a single signature, which is a prosecutor. Finally, there was good cause to extend the deadline. The trial court had already set the trial date in light of the circumstances. So to wrap up, this state respectfully requests two things. The first is just a clear ruling that initial aggressors cannot claim imperfect self-defense. For that ruling, the state does not need to, or the court does not need to reach the separate inherently dangerous felony rule. The state is also requesting that rule to provide analytic clarity and guidance to lower courts. The state respectfully requests reversal on the manslaughter issue.
Thank you very much, Mr. Snow. And man, you were spot on your time.
Impressive.
It was impressive.
May it please the court and opposing counsel. At its core, this case is relatively simple, legally speaking. Matthew Chavez attempted to rob the victim, but he subsequently withdrew from that robbery attempt. And when he withdrew, he recovered his right to self-defense as well as his right to imperfect self-defense. And that, I think, is as simple as it gets. I understand that there are a great number of concerns about these cases. And the facts are certainly complicated, and these types of cases often involve very complicated facts that are for a jury to resolve. And it is important that the jury be properly instructed in order.
Let me press on this idea a little bit, picking up on Mr. Snow's argument, that here we can look at the record there's sufficient information in the record for us to see that the jury rejected perfect self-defense, even though I think a few of us have questions about the jury instruction. And if that is the case, I think the state then further argues they couldn't kind of ring the bell on imperfect self-defense. What is your response to that?
I don't believe that that is accurate, Justice Bacon. The self-defense, the straight self-defense instruction that the jury was given required that the self-defense must be reasonable. And the whole distinction between imperfect and perfect self-defense is that in imperfect self-defense, the defendant held an honest but unreasonable belief. So it is not true that the jury necessarily rejected self-defense because they didn't agree with his withdrawal argument. It is entirely possible that the jury did not find self-defense because they felt his belief was unreasonable. The jury looking at the case said, Tyler Lackey sounds like a nice guy. I'm sure he was. He was the victim of a robbery. A criminal should not reasonably expect a victim to just arbitrarily kill them. But the question with imperfect self-defense is not whether Matthew's belief was reasonable, it's whether he honestly held it. And that's how I would distinguish that, Your Honor. The finding by the jury that there was not perfect self-defense does not mean they could not have found imperfect self-defense.
But they did find in instruction 30, these numbers 2, 3, paragraph 2, subparagraph 3, I guess. Tyler Lackey, self-defense is not available to the defendant if he started the fight unless Tyler Lackey became the aggressor. So you could argue they were instructed on that and on the provocation, that in fact they didn't accept that he was provoked.
Yes, Justice Thompson, they were instructed with the elements of withdrawal, but only in a perfect self-defense instruction that also had the requirement that he acted reasonably or believed reasonably that he feared. What I'm suggesting is that the Court of Appeals was correct in saying that he should have gotten the voluntary manslaughter instruction. However, this court may wish to suggest that the way to deal with that instructionally is simply add the withdrawal elements to the voluntary manslaughter instruction. In other words, you would have a voluntary manslaughter instruction that would say, you cannot find voluntary manslaughter unless you believe that Matthew Chavez, 1, withdrew in good faith, 2, communicated his withdrawal to Mr. Lackey, and 3, had an honest but unreasonable belief that he had to defend himself or others. I believe that giving a voluntary manslaughter instruction that mirrored those elements, just like the perfect self-defense instruction, would have cured the error in this case.
What do you make of, do we have to, if we were to agree with you, would we have to write a rule that says that this imperfect self-defense is available even in felony murder cases. That is, and tell me how you view the concurrence. They seem to raise this concern that the reason why the state of our law is so problematic is in a common sense way, if it's a felony murder and they act inherently dangerous and they're reckless, that now they cause all this chaos and now they get the benefit of the provocation. Do we have to write it that broadly?
I think, Your Honor, that the problem with this case and that argument is that the jury was instructed on felony murder, and they found that the elements of felony murder were not met. They may have believed any of the elements was lacking. The jury could have believed or found that it was not an inherently dangerous crime, and I would emphasize our position is that it was an unarmed robbery. The state's position is different. Those kinds of disagreements are supposed to be decided by a jury.
But we're looking at this, now on appeal, but obviously if there's a felony murder charge, a trial court judge isn't gonna have the benefit of looking at it after the fact. I mean, how would you address Justice Thompson's question, knowing that the judge is gonna have to decide prior to it going to the jury whether they get both the felony murder and the voluntary manslaughter instruction?
Well,
Is there a tension there? Are we creating this tension?
I believe it's quite clear that in a case such as this, he should have gotten both. The judge should have instructed on felony murder, and if the jury had found felony murder, this would be a totally different appeal. Arguably, if the jury had found felony murder, then they weren't even considering voluntary manslaughter, is the argument. But in this case, because they rejected felony murder and instead convicted of the lesser of second-degree murder, they may have been willing to convict of voluntary manslaughter. That may have been what they wanted to do, but they couldn't because the voluntary manslaughter instruction was not given.
So the reverse of what the state is asking is also a concern of mine. Does the trial court have the discretion to decide whether or not that voluntary manslaughter is instructed? Or are you asking for a rule that that step down must be given, that voluntary manslaughter instruction must be given? And under what circumstances?
I believe that the voluntary manslaughter instruction or the imperfect self-defense instruction that we're asking for in this case should be given under the same terms that a self-defense instruction is given. If there is any evidence that could make a reasonable juror believe, and it's a low standard. The standard for giving of a self-defense instruction is quite low. And I believe it should also be quite low for a voluntary manslaughter instruction. Indeed, I cited persuasive case law in my brief from, I believe it was Washington, D.C., where the court commented that perfect self-defense very frequently, if not almost always, warrants an imperfect self-defense instruction, if it's requested. Now, if the defense does not request it, that's a totally different story. But in this case, the defense did request the voluntary manslaughter instruction.
So if a court grants a self-defense instruction anywhere, as they did in this case, in any other step-down instruction or any other instruction, the imperfect self-defense must be provided in the terms of, in this case, the provocation. I don't know if I'd say must be in every case. I understand the judiciary likes to leave the door open for an occasional exception. I would say in most cases, in almost all cases, it would be correct for the court to give the instruction. And once again, this is a similar issue that we have recurringly with the self-defense instruction, where the law states that it should be given if there's any evidence that a reasonable person might find, and we find courts sometimes refusing to give the instruction, and it's a low bar
for both perfect and imperfect self-defense, and they often go hand in hand. I'd also like to point out that a lot of this discussion has involved the word mitigation, which has a general meaning, but in the law, it sounds like if you mitigate a crime, you're giving someone a benefit or you're helping someone. I would point out that in New Mexico, the voluntary manslaughter instruction is not, or the imperfect self-defense instruction is not an affirmative defense. It is simply a recognition that the crime did not meet all the elements of second-degree murder. In New Mexico, a second-degree murder is a killing with malice, a homicide with malice. And all Matthew Chavez was arguing was that, yes, he killed Tyler Lackey, but he did not do so out of malice. He did so out of an honest but unreasonable fear that Tyler was going to further escalate. After pulling a gun and chasing him, was going to actually shoot him. And even if the jury believed that belief was unreasonable and did not warrant a full self-defense finding, it is possible that they could find that it was honestly held but unreasonable and therefore warranted a finding of voluntary
So does the
manslaughter.
conviction of him for second degree change this because it's an affirmative finding by the jury of malice?
But the only reason the jury found second degree was they were not given the option.
No, they could have acquitted him and
Well-
said there was no malice and therefore we can't answer the second degree murder question beyond a reasonable doubt.
And that's an interesting point you raised, Justice Bacon, because in effect, what the state is saying when it says that there should not be voluntary manslaughter instructions in this case is it's a case of brinksmanship or the all or nothing strategy that sometimes defense lawyers will intentionally use, in which you either convict of the highest degree or you let them go. But in this case, the defense requested the lesser included. I believe the state would be satisfied with that situation because in most cases like this one, quite honestly, I believe a jury would be very hesitant to just let someone go or find that there wasn't any criminal liability for the killing at all. So what the Court of Appeals ruled and what I suggest is that they should be properly instructed and have the opportunity to choose the lesser offense if the defense requests it. And the defense did in this case. Otherwise, as I said, you would put juries in a very tough situation where you'd ask lay juries to act like judges and totally disregard the consequences of their actions and rule strictly on the legal technicalities. When in reality, I believe a lay jury probably found, yes, he killed him, he was in the wrong, but the question is not whether it was a homicide, it's what level of homicide. And in New Mexico, the legislature has laid out a scheme where homicides are varied by degree. There's first, there's second, and then there's manslaughter.
Then there's felony murder.
And there's felony murder, yes, Your Honor.
And that's why the state is
Ever
arguing.
complicated.
And that's what they do. I mean, that's what the felony murder statute does. Actually, it says second degree, you can be brought in first degree murder, absent the mens rea of first degree, but because it's so inherently dangerous. And that's very much what they're arguing.
And I would point out, Justice Thompson, that in this case, the jury did not buy the state's argument. They did not find felony murder. If they had, this case would be in a very different posture. But the fact that the jury was willing to consider lesser degrees of the crime is simply evidence that a voluntary manslaughter instruction should have been given, because a jury may have actually found him guilty of that. And I just point out that I believe there's a tendency on the part of prosecutors and sometimes the general public to look at a situation and first determine what sentence they think would be appropriate, and then determine what kind of crime the criminal should be convicted of. And I would argue that that's somewhat backward. The first matter legally is to find out what crime a person was convicted of, and then worry about the consequences. The state seems to be arguing that voluntary manslaughter is not serious enough. It's not enough time. And I would suggest that it's up to the legislature to change the scheme of murder statutes in New Mexico.
Well, they seem to making a pretty common sense argument, which Justice B. Hill addressed, which is if you're going to pick the fight, then how do you say he was the aggressor? I mean, that's a very common sense argument, that how can, under our criminal structure, someone pick the fight by robbery, because we know they convicted of that, and then claim the victim was the aggressor. That, you know.
Well, Justice Thompson, I believe that is kind of a common sense approach, and at first glance may be very appealing. But as people in the legal system, we recognize that life is a lot more complicated than we'd like sometimes, and the withdrawal from the crime, the withdrawal of an initial aggressor is well recognized. I cited cases in my brief going back to territorial days.
But he didn't
New
withdraw
Mexico-
until after he saw the gun. That's when he withdrew, right? I mean, the gun was in response to being robbed.
I don't know that the evidence necessarily showed that. There certainly were factual disputes about what was going on at the trial level. I know that Matthew withdrew. I don't know if it was in response to the gun. But there is an underlying question of what is a reasonable and lawful response to a crime that does not involve a dangerous weapon. And that's an issue that's quite controversial. This court doesn't have to wade into. I'm sure you'll have many opportunities in the future to decide those circumstances. Just anecdotally, just this past couple of weeks, there was a case in Albuquerque where a man battered someone at their place of work, and the person who was battered pulled a gun, followed them, and killed them. And now that person is charged with murder. I don't know the circumstances of that case, but I would just say if the facts of this case had come out somewhat differently, if Tyler Lackey had killed Matthew Chavez instead of Matthew Chavez killing Tyler Lackey, it's entirely possible I would be standing here defending Tyler Lackey. In these cases, there are so many factual questions that have to be resolved by the jury that we can't rely simply on charging discretion to determine how they come out.
So you mentioned, in addition to the voluntary manslaughter instruction, you're suggesting, and I can see why, including a withdraw instruction. Would you also, it's not going to apply here, but because felony murder, there was an acquittal, but assuming there wasn't and it was going to be retried, would you also include that withdrawal language in the actual felony murder instruction? Or just the sufficient provocation that's already in there?
As you said, Justice Zamora, it's not an issue in this case. I really haven't formulated an opinion about whether or not the withdrawal element should be part of the felony murder instruction. At first glance, it seems to me, I don't know why not.
Mm-hmm.
But as I said, that simply is an issue that was raised in this case and that we haven't briefed. I believe under the facts of this case, however, the voluntary manslaughter instruction, which should have been given, when it is given, if this case goes to retrial, I think this court might suggest to lower courts that adding the withdrawal element under facts like these is the best course of action. Of course, specifically how to instruct the jury is up to the trial court, and the attorneys have input. There is no one fixed correct answer to all situations.
And that wasn't preserved in this, the withdrawal language wasn't preserved in this case. They just gave a general UJI of voluntary manslaughter.
No, in this case, they did not give the voluntary manslaughter instruction.
No, I'm sorry, the defense counsel just asked for the standard UJI, not for he did not suggest an additional withdraw instruction.
No, I do not believe he did, Justice Amar.
Thank you.
One other point I wanted to make before moving on is that Judge Hannessy below, I believe, tipped this court off a bit when he said, when he felt that this issue, this conclusion was unjust, and suggested that either the Supreme Court or the legislature should fix this problem. As I said earlier, if there is a problem with the murder scheme in New Mexico, in particular with the requirement that there be malice for second-degree murder, then the legislature is the appropriate party to correct any problems like that. And I believe the legislature is better positioned to make what are often very publicly controversial determinations about crimes and how they're punished. So I would just suggest that, the whole separations of powers exists to ensure that one branch or the other knows what it is supposed to do. And I would suggest in this case that it is to the legislature that the people who criticize this decision should address their concerns.
Is that because it involves a redefinition of second-degree murder?
I believe so, Your Honor. Yes, Justice Beal, because as I said, second-degree murder in New Mexico requires that a killing be done with malice. And the imperfect self-defense instruction is that he didn't have malice. He may have had an unreasonable belief, but it was an honestly felt belief, and therefore he didn't have malice, did not intend to kill for an unlawful purpose. If there are no further questions along those lines, I'd just like to move on very quickly to the interstate agreement on detainers, our cross appeal. I'll just state out front that I understand that what I'm asking this court for is a big ask. To dismiss with prejudice a case involving a homicide, I know courts are loath to do.
Isn't it also, doesn't going down the path you want us to require us to overrule Aaron? Because Aaron sets like the lowest bar humanly possible for good cause. Show up, both parties are there, you say I need more time, de facto good cause.
Yes, and I believe that and Aaron is the state case, correct, Your Honor? A New Mexico case?
Yes, yeah, it's a court of
And I believe that the correct standard would be to use federal law, because as we pointed out, the interstate agreement on detainers is federal law, and I would point out that the federal standard is much higher. The interstate agreement on detainers, in terms of applying it in federal courts and interpreting it, is often done against the backdrop of the Federal Speedy Trial Act, which the state has no corollary to. In some cases in federal court, you get a trial within 90 days. New Mexico has no statute even approaching that. So I believe that
it should be something higher than that, which is
Yes.
articulated in Aaron.
Yes, Justice Bacon. And quite honestly, in researching this case and going with this case, attorneys often don't even file motions under the IAD because they simply don't believe that the courts will ever enforce it, or and I understand very well the pressure the courts are under and the tremendous logjam of cases. But the IAD envisions, and the state of New Mexico agreed, that IAD cases should be prioritized, that courts should make serious efforts to make sure that they are held within the time limits of the IAD. And I guess it's not part of my brief. I would just say generally that's not true. In this case in particular, it was not true. So I understand that even if the court does not agree with me that in this case, dismissal with prejudice is appropriate, I would suggest that the court might attempt to formulate a more stringent, even if not as stringent as I would like, a more stringent requirement for trial courts to prioritize these IAD cases. And perhaps the IAD will once again actually mean something to practitioners. And I don't mean to spend too much time on that subject.
Understood.
So does the court have any other questions? Okay. Once again, I would just like to say that this is a legally complicated case. It could be used as a hypothetical in a law school course. It involves withdrawal, which has been a widely recognized, long-established exception. And I believe that the Court of Appeals was entirely correct, that the jury should have been given the voluntary manslaughter instruction. And as I suggested, this court may want to suggest that adding the withdrawal elements would ensure that the jury did find that the withdrawal elements were met before finding a voluntary manslaughter. So, if there are no further questions from the court, thank you.
Thank you.
May it please the court? Counsel. So, defendant, and perhaps I misunderstood it, but by adding withdrawal language to the manslaughter instruction, sufficient provocation, that is essentially adding the state's proposed rule that initial aggressors, as a general proposition, cannot claim imperfect self-defense, that the jury would have to find that an initial aggressor withdrew. So on that point, the state agrees that that would be a good way to implement the state's requested rule. And this court, even if it doesn't go for the broader rule, that an inherently dangerous felony is a per se aggressor, still under that rule, defendant wasn't entitled to an instruction, and if he was, any error was harmless. Contrary to defendant's claims on appeal, his claim below was not
What
that,
language would you use for the withdrawal portion?
I would mirror the withdrawal language for the perfect self-defense instruction,
Okay.
just to ensure that they're identical.
Well, the provocation instruction says you don't get provocation if they could have cooled off.
Yes,
Is
Your Honor.
that different?
I believe that cooling off applies in different circumstances. It's possible it could be shoehorned into that in some cases. So his claim at trial was not that he had an honest and unreasonable decision to kill. His claim was that he withdrew. This was a justified homicide, and the jury rejected that. The jury was instructed, as Your Honor pointed out, that that was one of the alternate bases it had to consider for determining whether or not defendant validly exercised his right to self-defense.
Yeah, but we don't know if that's why they rejected self-defense. I just have a problem with all this speculation about what the jury did and didn't do, because there was multiple elements they could have relied on to reject self-defense. I'm just wondering why you think it's not harmless error without going into what we think or didn't think the jury did or didn't do.
Sure. So to try to restrict it more, we know the jury found that he committed an attempted robbery. And we know that the jury didn't acquit entirely. So we know that they either found that Tyrolaki didn't use unreasonable force or that defendant didn't effectively withdraw, one of the two. Given the facts, it's from that basis that, and defendant's theory below, that would, because imperfect self-defense is a lesser included, as the defendant correctly pointed out, it's not a perfect self-defense. So the standard is their rational view of the evidence that would have let them convict for voluntary manslaughter but acquit of second-degree murder. And it's the state's submission past that point with those findings by the jury and with what defendant asked them to do, that they didn't do a third thing.
Perhaps the defendant was forced to ask what he asked because he didn't have an imperfect self-defense instruction. That is, when the judge refused the imperfect self-defense, he's pushed in the corner. The only thing he's got to argue now is that he withdrew.
Your Honor, his claim was perfect self-defense in the opening as well, before the court denied the voluntary manslaughter.
Perfect self-defense.
Yes, Your Honor. That was his claim.
Not whether or not his fear was reasonable or unreasonable. So,
absolutely, Your Honor, in opening. As for the defendant's separation of powers claim, although it's true that manslaughter and second-degree murder are statutory crimes, imperfect self-defense is a common law doctrine. This court essentially created it or reflected upon previous cases and fully articulated it as a doctrine in Avieta. So if this court can recognize a doctrine, this court can make reasonable changes to it. The defendant's argument that this will lead to all or nothing situations, that argument lies with equal force against Gaitan. So if this court were to deny an initial aggressor rule generally, it leaves Gaitan in a very strange spot doctrinally. Because under Gaitan, someone's not entitled to a manslaughter instruction if they start with an intentional assault. So it's unclear why, in those cases, defendants should not be able to get a manslaughter instruction, but for broader provocative conduct, they should be able to get an instruction. As for the IAD point, the state disputes that federal courts apply a higher standard. It's the same standard. It's just there's such a thing as the Federal Speedy Trial Act. And so that gets brought up in similar cases. It doesn't get brought up in New Mexico. It's not that the standard is higher.
It's just the two live side by side in the federal construct.
Exactly. So to sum up, the state's asking for recognition that initial aggressors cannot claim imperfect self-defense, that a further rule that initial aggressors who commit an inherently dangerous felony should not be able to claim this defense. And finally, asking this court to affirm the Court of Appeals decision on the IAD matter. And if this court has any further questions, I'd be happy to answer them.
Thank you very much.
Thank you, Your Honor.
Gentlemen, thank you for your arguments here today. As both of you know, the case is now deemed submitted to the court, and we will get you a decision as soon as we can. Thank you so much.